So welcome to today's Tuesday talk on renewable energy investment disputes, challenges and opportunities by Ma Sai. Sai is a PhD candidate at the Faculty of Law at the Chinese University of Hong Kong. Her research focus is on investment arbitration, energy dispute resolution, and environmental policy. She is currently a fellow at the IASS under the Green Talents Program of the German Federal Ministry for Education and Research. During her time at the IASS, she focuses particularly on the hydrogen economy and international investment law. Before we start, as always, please keep in mind that we will record this session. And now, Sai, please, the floor is yours.
Thanks, Achim, for the introduction. Could you see the screen, like the shared?
Yes, we can.
Everything working? Great. Okay, so I'll just start my presentation, and thanks a lot for being here today. And I really would be very delighted to have the opportunity to present my PhD project that focus on renewable energy investment disputes. And it's often the time that the one I introduce to people about my PhD projects is focusing on renewable energy investments and from the lens of the international investment arbitration. I often would get a question that why arbitration? What is investment arbitration and this community to do with environment? Because the people often get an impression that investment arbitration is dealing with this commercial and investment related issues, and environmental law and environmental issues should be fall on the shoulder of environmental lawyers. And I also have this impression at the very beginning. And the reason that why I started to work on this topic is that during my internship at an arbitration institute in Stockholm, that I encountered a very interesting group of cases which brought by renewable energy investors against the whole state. And here is an example of this type of cases. I just took a very quick screenshot. Under these cases are all available under the public domain published by the Energy Charter Treaty. And this group of cases is extremely interesting to me because they share a lot of similarities. This is just one example, because all the cases were brought by renewable energy investors, and the subject matter of all the disputes are related to legal reforms affecting the renewable energy sector, which you can be found on the right-hand side of the screen. And they are ruling by the same kind of treaties, which are relevant to the ECT. The full name is Energy Charter Treaty. And the applicable law and the legal claims are built on the same clauses. And why it become interesting is like that previously it's very hardly to find a lot of these disputes that brought by the so-called green investors. Of course, there are a lot of disputes on whether these investors could be considered as green or not, because they invested in different sectors in the energy sector. Some are also invested in fossil fuel projects, also in renewable energy projects. But it's very interesting because the shared subject matter of the disputes is the same, but the result are kind of different. It's kind of like controversial. And intuitively that I think maybe there might be a link between decarbonization and investment arbitration. And I would be very interested to see that whether investment arbitration could contribute or at least could play a role in the decarbonization process. But before that we go deeper into the legal issues that are involved in this case, is that I think is very necessary for us to review what's happening. So why would this country started this kind of like legal reforms in the renewable energy sector? What's going wrong? Because if there is a dispute that go to the law and under the dispute settlement process, which means the conflicts between the two parties are kind of very escalated. There is no way for them to solve the problem through negotiations and other alternative resolution platform. So I think that all of us are involved in this renewable and sustainability studies, so we're quite familiar with the climate change issues and about this decarbonization and renewable energy deployment, and then the request for the whole energy sector to shift from a fossil fuel base to carbon free. So this is kind of clear. But how to make it happen? One of the very important things to make it happen is that renewable energy deployment or decarbonization in general need investment, a vast amount of investment. And this investment should not only rely on public funding and spending. And fundamentally, that we need to try to think how could we trigger and direct private parties to get involved. How do we direct these capital flows, the private capital flows into the clean energy sector? But there is a barrier, is that renewable energy investors are facing a lot of risk. It's a very risky investment activity due to two things. One is that renewable energy investment normally requires a vast investment at a very initial stage. However, investors are going to wait for a very long time to get their investment return. And it is exactly because of this feature that make renewable energy investors extremely vulnerable to external crisis or any kind of changes. So from a whole state's perspective, or from a state's perspective in general, one of the questions is that how should states, what kind of an instrument available for states to try to reduce the risk that renewable energy investors might be facing? And among all these kind of available tools, one of the tools would be regulation. This is commonly used by states because they try to use regulation to increase the confidence of investors, to make sure that investing in my country and in the renewable sector would be safe. So regulation in general have two functions. One is that this is a very narrowly targeted instrument and with a very specific goal. In the context of renewable energy regulation, renewable energy regulations involve the very specific renewable energy targets, because all the states adopted renewable energy regulation because they want to use the regulation to reach the renewable energy goals, targets. And these targets are very specific and with a very specific timeline in general. And second of all is to try to use this regulation, renewable energy regulation, to respond to specific risk that, as I mentioned at the very beginning, this might be investment risk, might be regulation risk, might be financial crisis, and so on. They try to use regulation as a way to provide stability for investors. So the rationale behind this investment and regulation relationship is quite simple. It's using renewable energy regulations to attract investment in order to achieve the renewable energy regulation target. So built on these assumptions, many states have started their renewable energy regulatory process in order to attract investment. Spain is certainly one of the front runners. Actually, since the very beginning, at the beginning of the 1990s, that Spain has already considering how could they deploy the renewable energy. And because you think about Spain, the environment endowments and the solar resources and so on, it's a country that has a lot of these conditions to attract renewable energy investment and to to increase the renewable energy share in the energy sector. And in 1997, this is also a result of the Kyoto Protocol and about the climate movement at that time. And Spain adopted the electricity law. And this law, electricity law, is very important because it actually set the foundation of the whole renewable energy regulatory framework in Spain. And one of the most important feature in electricity law 1997 in Spain is that the Spanish government distinguished two separate regimes. One is called the ordinary regime and the other is called special regime. The special regime is specifically applied to renewable energy producers and operators. And the key differences between these two regimes is built on the calculation of the remuneration, which means that if you're a renewable energy producer and operator, that you would be entitled to more subsidies. You can receive more subsidies that are provided by the country. The intention is very clear because Spain tried to attract more renewable energy investment and investors in this clean energy sector. And a very common subsidies that not only used by Spain, but in many of the countries is called a feed-in tariff, which basically try to guarantee a relatively stable amount of remuneration provided for investors for a fixed time period. Normally the feed-in tariff, the time would be granted to investors and for about 20 years or some even above. And it is because of that, stability has become is the most important feature of this feed-in tariffs, because the intention is to give investors a guarantee, a commitment that as long as they invest here, you're going to you can receive the fixed amount of money remuneration, a return of the investment, and for a very fixed amount of time. But it is exactly because of this stability that caused a lot of disputes and the problems later on. And after 1997, from the period of from 1998 to 2008, in the following 10 years, Spain has enacted and deployed has enacted a series of decrees and regulations. And among all these regulations, I find there are like 3 regulations that are very important and are highly relevant to the disputes that we're going to discuss today. And the first regulation has been issued in 2004. And this regulation has also a very clear goal, as I mentioned before, is to provide investors incentives and also want to increase stability. So the regulators include a very specific stabilization clause in the law for saying that the changes of the subsidies that are provided would not affect it to the facilities that are already in operation. And from these stabilization clauses, I think it sent 2 very strong signals. One is that the law might be changed in the future, but such changes wouldn't influence and wouldn't really cause any negative impacts on the investments and the plants that have already in operation. However, after enacting the law in 2004, the Spanish government has recognized that it doesn't seem to work that well, and it didn't really bring the sufficient and their expected amount of investment. So in 2007, they issued another law trying to strengthen the profitability that the investors could obtain, and also trying to provide even more stronger stability for investors. And so here you can say the stabilization clause also maintained in the regulation 2007. The revisions to the regulated tariff shall not affect facilities for which that blah, blah, blah. And it also showed a very strong tendency, and it also mentioned about the priority of the law, that one is stability, the second is profitability. And in 2008, that Spain continually changed the law a bit. Well, the basic incentives remains. However, the significant change is that the stabilization clause that we could see in 2004 and 2007 regulations have been removed by the government, which means that, you know, there's no guarantee and the law would not be changed. The law would be changed, but there would be no guarantee that the change of the regulation would not really affect it, that the plants have already in operation. So these are the 2 graphs that I found on the IEA and Bloomberg's new energy finance to show that after the enactment of the regulation, what happened in Spain. We can see the graph on the left-hand side is about the solar PV electricity generation. It's very clearly that, you know, starting from the early 90s to 2005, it's pretty much the amount of the electricity generated from solar energy was still very low, but there certainly is a sharp increase of the electricity generation from the solar PV after 2005. So many of the people, the interpretation of this change is due to the strong and very generous incentives that the Spanish government provided for renewable energy producers and operators, and also because of the strong regulatory support for renewable energy investors. And on the right-hand side, we can see the investment landscape has also changed a lot in Spain from 2004 to 2017. At the beginning, you know, in 2004, even though we have the law enacted in 2004, but there's still not a very high amount of investment that in the renewable energy sector. But in 2007, it's also a sharp increase that actually peaked in 2007. And it's very easily to think maybe that's also a correlation between the law in 2007 and that actually attract more investment in Spain. And in 2008, this remained a very high investment level. However, in 2009, there's like a sharp decrease. Well, this made us think about 2 things. First of all, it seems that the law really has a very positive effect on investment attracting and promoting investment in renewable energy sector. However, on the other hand, we also see there caused an investment boom in 2007 and 2008. And such an investment boom, on the one hand, can be positive. On the other hand, it also increased the regulatory cost, which means that the Spanish government has already provided very generous subsidies for these investors. But because of the investment boom was somehow unexpected, that immediately increased the cost the government should burden and should pay for the investors. And that might be a fright for the government, and might cause some like financial issues. And at the meantime, in 2008, as we probably still remember what happened, is the global financial crisis. And Spain has this long history of having a tariff deficit, but because of the global crisis, which actually make the situation even worse, in particular, like in Spain, Italy, and Greece, and so on. And we can see from this graph that actually in 2008, the tariff deficit that Spain is facing peaked is extremely high, and 2009 as well. So this caused a lot of burdens for Spain. On the one hand, it's about the regulatory costs, and the other is like to respond to the tariff deficit. And so the Spanish government really were thinking that they need to make some change. And why there would be so serious conflicts that we could observe in Spain? One of the diagnoses, or many people think, is because of the design failure that embodied in the renewable energy support schemes in Spain, which means the IFIT. Because Spanish government apparently is overemphasized on stability and overemphasized on importance of boosting and increasing investors' confidence. However, it is exactly because of this stability that caused the instability of the regulations. Because it made the renewable energy regulations in Spain be incapable of corresponding to the external crisis and exposed changes, like a financial crisis, like the investment boom. So apparently the stability and the flexibility balance has been broken that within the renewable energy regulatory framework in Spain. And facing such a situation, it seems that it left Spain no choice but to change the law. So this table actually shows from 2009 to 2014 that Spain has started a series of legal reform in the renewable energy sector. Very interestingly, that we could see that the changes in 2009, 2010 seems to be quite mild, which means that seems like an incremental adjustment. It has some limitations on the remuneration, the amount of remuneration, and has sent some cap to the operating hours. Also, like increase a bit of the cost of the revenues that investors could obtain. But since 2013, that we can see the changes seems to become more radical. And especially as the law that I highlighted here, the law 24/2013, is limited the distinction between special regime and the ordinary regime completely, which if we still remember that I mentioned, this is the fundamental feature of the renewable energy regulatory framework that has laid down in Spain in 1997. And this feature has been abolished in 2013. And then and then later, it changed the whole calculation method of the remuneration which the renewable energy investors could obtain. And in general, I think if we look at the renewable energy regulatory reform in Spain, it could be divided into 3 different phases. At the very beginning, it's in 1997, it set down a very fundamental framework of the renewable energy regulation framework in Spain. And from 1998 to 2008, I call it a development phase, which during these 10 years, Spain constantly issued the law, tried to implement and complement the electricity law, the framework of the renewable energy electricity law in 1997. And then it's the legal reform, starting from 2009 to 2014. And but the renewable energy regulations flexibility and stability imbalance is not the only conflicts that we could see in this crisis. It is because of the imbalance between flexibility and stability that initiated another kind of conflicts. I think if we look at it from the investors and from the state's perspective, both parties have realized that the law should not be frozen. And this signal has already been sent by Spain, at the very beginning, because it's constantly mentioned, that future changes might happen. However, the real disputes, in my opinion, between these two parties lies in who should pay the cost that arising from such a legal reform. Because if you want to change the law, it would be costly as well. And how are you going to distribute the cost? Whether it's the consumer pay the cost, the Spanish government bear the cost, or you transfer the cost of this the regulatory reform to investors. On the one hand, from the state's perspective, it argued that we have the right to regulate and we can change the law when it is needed. But from the investors' perspective, the investors also argue that we have the right to our investment, and our investment right is protected under international investment law. So this would lead to the cases that we see at the very beginning, the conflicts between foreign investors in renewable energy sector and the host states has been escalated. And there's a huge amount of renewable energy cases have been, well, by saying a huge amount, it's really, was not necessarily that much, but to the international investment law community, that's really a large number of claims against the host states could be seen in the international investment arbitration. So before they move on, I think there are some very general concepts that I want to introduce a bit, because I think not everyone is that familiar with international investment law. International investment law is a very unique legal regime, and basically it is constituted by two parts. On the one hand, it's about international investment treaties, and most of these treaties are bilateral investment treaties that concluded between two states. It's a result, in my opinion, is a result of compromises and intent with a very clear goal as the intention to protect and promote a cross-border investment. But the unique feature of international investment law is that the other part of the law actually was involved by the abundance of this arbitral jurisprudence, is the cases, and which these cases were decided by, was settled through a platform, which often referred to the investor-state dispute settlement. We also call that ISDS. And this platform allowed foreign investors to bring a claim against a host state in which they have invested, bypassing their domestic jurisdiction and to normally is an ad hoc based arbitral tribunal. And in the investment and the renewable energy investment cases, the context and the cases are all under a treaty that was called Energy Charter Treaty. And this treaty is very unique and special. It's because it's the only multilateral investment, not only investment treaties, but it's the only multilateral treaty that's in the energy sector and covered a range of energy-related issues. There are many parties that concluded that Germany is also like the EU, and Spain, Italy, Czech Republic are all the member of the parties to the treaty. And all these cases are also, there are a lot of substantive protection standards that under international investment law, which foreign investors could rely on to bring their claims. And the most recent and most controversial one referred to the fair and equitable treatment standard. And this is also the standard that most of the renewable energy investors rely on to bring their lawsuits. So let's see what this standard is really about. Well, I'm not going to read this, but I highlight a few words. It's basically saying, states should help to create stable, equitable, favorable, and transparent conditions for contracting parties. And then if you give the investors a commitment, and you the better accrue this at all time. But this texture and the wording actually, I don't know how you feel, but when I first read it, I got a very strong sense this is very ambiguous. how are you going to define stability? How are you going, what is equitable? What is favorable? And how transparent is transparent enough? And what could constitute a commitment? And what are the sources of the commitment? And what type of commitment that a state give would be considered as a commitment under Article 10.1 of the ECT. And actually, there's no consensus among these issues. And all these concepts are still a very abstract sense. And it really relies on tribunals' interpretation and also demand a second guess. It's kind of like a catch-all substantive protection standard, but with very weakness and open-ended. And it is exactly because of such feature of this IFT standard under the ECT that caused a lot of controversies among scholars and legal practitioners and so on. And I'm not, because of the time constraint, I'm not going to go into details about these issues. But because of the cases and because of the interactions between international investment law and decarbonization and renewable energy regulation and state sovereignty to regulation and regulatory risk, there are a fierce debate among scholars and legal practitioners in the investment arbitration domain and also in the environmental law groups. Well, there is a group of scholars and legal practitioners strongly against ISDS because they think ISDS and international investment law have become a weapon that could be used by those foreign investors who are often those national corporations with strong power to influence states and to limit a state's capacity to improve its national environmental standards. It has already jeopardized a state to improve environmental protection and to execute their regulatory right. So from the lens, from the eyes of these opponents, and ISDS and international investment law or foreign investors are the enemy to environmental group, environmental interests. And they are naturally against the environment. They would, there are those evil investors and cause a lot of problems in environmental conservation and so on. But it is because of the currents of this renewable energy disputes under the international investment law domain that raised another type of voice. There are a group of scholars and legal practitioners actually see this as a chance and opportunity for the renewable energy investors or clean investors in general to use this as a weapon to make states to honor their commitment that they made for decarbonization or for environmental protection. Because if we think about the problem in environmental governance from the legal perspective, it's because environmental law, we have a lot of all kinds of environmental law, but one of the problem of these laws is that it's a lack of enforcement scheme. Many of the ideas and the treaties cannot really be implemented and enforced in practice. However, international investment law and the ISDS actually gives the investors an opportunity to enforce the state's environmental policies and renewable energy policies. So there's a lot of debates going on in these issues. But when I'm studying this topic, that I think each group of people, like both the opponents and proponents, explained part of the truth, and they also make some like valid point. But but it seems like they only show part of the reasons and a part of the truth, and they're like kind of just to choose to look at it the perspective from their own perspective and the perspective that they want to believe. But neither of them really show the completely story and a comprehensive and a view. They only choose one angle to view this issue. If we put this agreement aside, I think international investment law and all these disputes actually provide a great opportunity for us to reflect what are the fundamental issues and in decarbonization from a legal perspective. I think there are two issues that need to be addressed and require sober reflection. The first is, what actually makes good renewable energy regulation? And the second is like, facing such a global issue, so complicated issue like decarbonization and climate change, regime interaction and conflicts are definitely inevitable. So how could we find a balance between all these entanglements in the law? And how could we really reconcile or like minimize the conflicts, but maximize the synergies? Even though all these principles and the conflict and interest have different legal roots and hold different values. And can we reconcile them? Can we put them on a global basis and to reach the same and similar goal, like decarbonization? And these two questions really deserve more attention and serious answers. However, I haven't really seen a very comprehensive answer that probably addressed these two questions. And I've been reading Jared Diamond's book, Upheaval, Turning Points for Nations in Crisis recently. And the sentence that he mentioned in the introduction part, I think is really resonated with the issues that I've been talking today. And it really deserves a lot of discussions. And I'm also curious about what's your opinion on this. If we think about a challenge, as he said, for nations as for individuals in crisis, is to figure out which parts of their identities are already functioning well and don't need changing, and which parts are no longer working and need changing. If we think about the problems that I identified or the conflicts that in the renewable energy regulation and investor and states disputes, it's also about what part of the law should be stabilized and what part of the law should remain flexible. And what part of the international investment law and these treaties can be improved, and what part could be served as an opportunity that could be used by people to reach the decarbonization goal. And I'm also willing to hear about your opinion on this. And this is pretty much the presentation that I'm going to give today, and I welcome all kinds of questions and discussions. Thank you for your attention.
Thank you very much, Sai, for the presentation. And I will just say we start directly.
Oh, sorry, did I click some?
I don't know actually if I clicked something or so. It's fascinating. Anyhow, we can directly delve into the discussion. Who would like to kick us off with a comment or question or so? If nobody has one, I would have one. I would like to start with the question. Do you in your project, in your PhD, actually also reflect on the questions like, for example, the role of the WTO, the role of other, let's say, cross-border investment activities? There has been TTIP, there's been TPP, and so on and so forth. So how does this all interact actually in this weave of different sorts of investment laws? And after my question comes, of course, John's, but now please, my question. Thanks, Sai.
Thanks, Ahim. No, I don't really focus on WTO because WTO is pretty much focused on trade. And I want to kind of limit my my research just focusing on investment, because investment law is a very unique feature, and I don't want to expand this projects to cover all kinds of topics. But I would be very interested in looking at these issues later. And TTIP, as you mentioned, because one of the highly debated issues is also about ISDS and TTIP, because it's about investors' right and states' right to regulate. So even though I only look at the Energy Charter Treaty, but I think this kind of question and the issue and the conflicts that I raised are kind of general questions, as long as it's related to investors' right and the states' rights and relate to the regulators, flexibility and stability. It's actually exists in all jurisdictions and in all kind of like international framework. So I didn't really specifically look at this two international governance and this, but I think most of the questions are common questions, but I would like to have the opportunity maybe to look at that in the future.
Okay, thanks. John, please.
Yeah, sure. Thanks, Sai, and I appreciated the presentation. It's a topic I know almost nothing about, so I apologize in advance if my question is based on that ignorance. But it seems to me that my impression would be that the role of regulation in ensuring both stability and return on investment would be very different, say, a decade ago when renewable energies were not cost competitive in the marketplace, as opposed to now in 2022, when my understanding is, at least in many contexts, renewable energy is competitive with, or in many cases, cheaper than fossil forms of energy for many uses and in many places. And so I guess I'm just wondering whether that external change, I guess I'm just wondering how that external change shapes the issue that you're looking at in general. And then maybe more particularly in terms of, what you described as sort of the question of the different scholars looking at this have of whether or not this benefits multinational corporations or not. It seems like that too, like the assessment of those scholars would change based on whether or not these forms of protection and regulatory protection for stability and return on investment are in an environment where otherwise it wouldn't be cost competitive at all, as opposed to where otherwise it would be, perhaps very an attractive investment even without that regulation. So if that makes any sense, the sort of the general question.
Thanks, John. This is a very relevant question. Actually, there are also a lot of arguments on this because, now, for instance, in Spain and in Europe in general, they're moving from FIT, the feed-in tariff scheme, to auction, because that's exactly as you addressed the dramatically decrease of the cost and renewable, the cost in renewable energy development and the maturity of the technology. And so many scholars and many people actually arguing it is because of this. So renewable energy could have a market-based mechanism. It's more like the traditional energy. But I hold a different opinion. I think the problem is not about which support scheme that you included in your regulation. I think that the fundamental question for renewable energy regulators is that how are you going to coordinate targets, your renewable energy targets and the support schemes? And because you can always, change from, one to the other, like auction, but as long as the renewable energy deployment is target driven, and this target is a very specific number and have to be fulfilled within a specific timeline. And so the fundamental question is the coordination between target and support schemes. And for instance, in Italy and in Czech Republic, they have outperformed years ahead, like as they firstly predicted, said that they also need to trigger the regulatory changes. And the most difficult challenge for regulators, I think, in this field is like, how are you going to really coordinate the target and support schemes? And without solving this problem, I think history would repeat. If you think about hydrogen, this is my research projects that I've been conducted remotely at IASS. If you have a new clean technology and an immature technology just emerged, I think you still need a very strong regulatory support at initial stage. And then you probably need to provide more stability. And if that's the case in the future as well, so you still need to face this like stability and flexibility dilemma and this challenge. And without really changing the thinking pattern of making regulation, without probably answer the question, what makes good renewable energy regulation, the failures will still be there. Because there would always be new technology emerging, new resources and new possibilities that need strong support at initial stage. Maybe renewable energy has already passed that phase, but then what about hydrogen economy? What about the other unknown technology in the future? So the real question that I think is for regulators' perspective is to think about what you could control and how to control it, what you can't control. It's not all the uncertainties that need to be controlled by regulations, and you need to clearly identify what are risks. And once this risk happens, once an external threat or crisis happens, do you have a plan B to adjust your system? And could you include this flexible mechanism to address and to respond to such a crisis exposed? And in my opinion, what have happened, and we witnessed these failures in Spain, in Spanish cases, is like it seems that it replaced the entire system. Because of the cost reduction, because of the high regulatory cost, they just replace everything. But in my opinion, I'm not enthusiastic about any radical changes. I think what we need is repairment rather than replacement. I think a targeted treatment is better than a revolutionary regulatory changes that would reduce the cost that be it bear by the investors or states or end consumers. So that's my response to your question. It's very relevant, but I just hold a bit of different opinions towards some, many scholars, they think they're more positive, but I'm kind of, have a lot of reservations about the regulatory making process in this field.
Thanks. Natalie, please.
Thanks, Sai. So I have maybe a few related questions. As a political geographer, I suppose we in geography are always interested in very specific questions, one often being a question of scale and another being a question of place. So my broader question is, for you in your research, at what scale are you most interested in making a contribution with your research here? So are you, like, you've been talking mostly in the abstract, like at the global international scale, but the case studies are rather specific, right? Like Spain is a very specific case versus the other examples you gave, Czechoslovakia or wherever else it might be. So how do you then relate that sort of international scale with how you focus your case studies? And like, is that a really relevant issue for you? Are you trying to propose also just a broader international global approach? And then, yeah, I suppose sort of related to that is just a question of methodology. So how are you going about doing this research? Would you say that you're doing a largely like case study specific approach, or are you really trying to create like a global perspective in your analysis also?
Well, thanks a lot for the question. Because that part I haven't really included in my presentation is because actually the essential part of my dissertation is case studies, which means that I read all this renewable energy cases, like it's related to Spain, has been rendered in the Word, and also against Italy and then Czech Republic. It's very specific, but it's kind of difficult to present that part to the audience that to the very general from different backgrounds, because that part is really very specific. These legal technical issues, I focus on a very specific clauses under Energy Charter Treaty. So yeah, case study is the main methodology that I use, and it's a very traditional like legal approach to like the facts of the cases and then the applicable law and how the tribunal interpret the law, and the other part is like how they apply their interpretation into the fact-based cases. So that constituted an essential part of my dissertation. And referring to your question of whether I want to build a more general international approach, no, I'm thinking about that, but in my PhD, that actually what I propose is more like I take international investment law a very specific angle to view these disputes, because if we're handling a very complicated issue like decarbonization, I don't think that we can understand the problem, the conflicts by just looking at the renewable energy regulation in isolation. And we need mirrors to reflect it, what's really going on. And I think international investment law provide a very unique angle from the regime interaction, legal regime interactions perspective, to see what's the problem, first of all, embodied in renewable energy regulatory design, and second of all, what are the potential conflicts that might happen in the future. So that's my goal. It's pretty much, I probably wouldn't really offer treatment, but the intention is to really give the right diagnosis first, and maybe the treatment will come to the next phase. I hope that addressed your concerns.
Yeah, can I ask a follow-on question then? Because I mean, I think this is really interesting, and it sort of, I mean, it raises a lot more questions for me, but one is certainly, what about countries or contexts where there is a legal system, but political corruption or authoritarian systems, whatever it is, have ways of getting around the legal system? So are there ways to account for that? Are those examples worth considering? Are you really only interested in contexts where there is a functioning legal regime?
Regarding to that question, actually, what happened? A huge amount of these cases that contributed. It's exactly as you mentioned. It's most of the time is an investor, foreign investors from a developed country, and they brought a claim against a developing country. For instance, in the early 2000s, a lot of cases are against Argentina because of the change of the law is more frequently, and well, the belief is that like developing countries link of the rule of law tradition, so it's link of the legal stability. So that has happening in the past. But now, like in the Spanish cases, we kind of see a new phenomenon in this international investment regime. Is like kind of both party investors are also from the EU country, and also Spain, Italy, and the Czech Republic is also from the EU. So it's a kind of change the whole investment landscape and disputes landscape a bit. But I think the real question, as you mentioned, is very relevant because it's actually linked to the question that I posed by lately is the debate whether international investment law could be used as a tool to enforce a state commitment. And this commitment also related to the rule of law principle, legal stability, and in what sense. But then there is another concern is like, I think all these questions actually could link to a more abstract one is what should be considered as a reasonable regulatory space. We all agree that the state has a sovereignty to change the law, but there's no absolute right. You must follow certain rules, be it substantive procedure, substantive rules or procedure rules. And the real question is like, who should draw such a regulatory space, and who has the right to do it, and where should we draw this boundary? And there are a lot of disputes ongoing. But from my personal perspective, I think it wouldn't be settled in a very short time period, but it's okay to have this discussion, to have this open discussion. And I don't think we can lead to a final say, where is this law? And this has to be adjusted, and it's a case-by-case approach. And we need this type of flexibility and this free zoom and to address, to see where to go. It's more like a dynamic equilibrium rather than a static one. So that's just a very general response to the question that you posed.
Thanks. Anyone have an additional question, comment? Then I would have two, actually. The one question I would have, you've just mentioned, could international investment law be used as a tool to improve decarbonization? I would be interested, what would be then the agency, because a law is a law. Which forum would be the appropriate forum? Which state could put this forward? And what does it would actually mean? I mean, would Germany push it forward? Would the European Union push it forward? Who would be actually the actors to use international investment law as a tool to contribute to decarbonization? And the second thing, perhaps a bit more like to the question what Natalie actually mentioned on geography. So your focus is, as I understand it correctly, on Spain, Italy, and the Czech Republic. So 3 countries of the European Union, which are operating in a, let's say, investment environment, which is very strongly controlled by the European Commission, or let's say the European Union institutions actually from Brussels. And so it's not really transferable to other parts of the world, like Latin America, Africa, or Asia. So that would be the second question.
Yeah, it's the first question. Just a very quick response. Actually, the EU is strongly opposed to the International Investment Arbitration Forum because they want to replace it by a court system. But I have a lot of reservations about this, the EU's proposal. Of course, because all these cases are against the EU member states and would actually limit their regulatory space. It's not what the EU is willing to see from my perspective. But I don't think a court system would solve the problem, because you think about that, and most differences between court system and arbitration is that arbitration is more competitive. But a court system sort of have a monopolistic element in that. It's the judges who are appointed judges, right? It's a permanent, and there's abated by the jurisprudence. But arbitration, on the one hand, you can say it's a blessing and also a curse because of this flexibility, because of this bottom-up approach, its competitiveness among arbitrators that cause a lot of controversies and inconsistency in their ruling. But on the other hand, it is because of such diversities that provide different opportunities and allow lawyers to also take innovative interpretation approach to solve the new environmental challenges. So in that regard, I can't really give a very simple answer that who would be the driving force, because now most of the states, I would say, like especially the EU, strongly opposed to use this this arbitration forum, and they kind of want to propose a significant reform of the Energy Charter Treaty. But where the future lead, I don't know. But from my perspective, I think international investment arbitration has its own values. And it really depends on what arbitrators, scholars, commentators, and regulators, states, and investors. It's a joint effort, and what we see and how all the actors try to strike a balance. And I don't think a top-down approach or the leaders could guide the development of this dispute settlement forum. Is really need more debates ongoing. And for the second question, I'm sorry that I didn't really catch the main part. Do you mind to repeat a bit on that?
No, the second question would be just to understand your case studies are Spain, Italy, the Czech Republic.
Yeah.
And the thing is, if you look, for example, at the taxonomy which the European Commission has just developed released a few months ago, it is not that the free states actually can make their own energy policy independent of the European institutions, which raises the questions to what extent it may be transferable to other parts of the world. So the investment law case is something for the European Union maybe, and with the different, let's say, variations within the specific states and so on. So I just wanted to understand which cases are you looking at and about the commonalities and if there is transferability to other parts of the world.
Yeah, thanks, Achim. This is a very valid question because exactly as you mentioned, these are all European Commission has, because the member states has their flexibility to make their own, to adopt their own targets, but still you have this limits at the European Commission's level. Exactly that I'm looking at Spain, Italy, and Czech Republic because these are the most controversial cases in the renewable energy sector because they have this renewable energy legal reforms. But I think it's but the problem is still is a general problem. For instance, take China as an example. Stability and flexibility is also exists in the Chinese decarbonization, China's decarbonization approach. Because for instance, the central government actually adopted the targets, but on the provincial level, there are many controversies and also many obstacles that are preventing to implement the central government's policy. And like electricity crisis and happened last year and so on, this also shows this flexibility and stability conflicts. And I think this conflicts actually generally exist in all kinds of jurisdictions. So. But the EU is a bit more complicated. It's exactly because of this structure that limit the member states' hands on one, limit the member states' hands that cause more controversials. But in general, be it in the EU or in a country like either US or China, I think all the regulators are facing the same dilemma and the same challenges.
Okay, thanks. We have a few minutes left. Any other comments or questions to Sai? If this is not the case, then I would say, Sai, many thanks actually for a presentation. It was quite interesting and would love to go more deeper to the discussion at some point, how to compare China and Europe, as apparently there are some similarities and some dissimilarities. And otherwise, I would wish you all a great afternoon and see you somewhere around digitally or in person. Bye.
Thank you all. Bye.
Bye.